There, Mr. Buckner. Sir, I will give you an opportunity to address the court, but you're not going to interrupt You're not going to interrupt anybody. Go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that, Nelson?
Your Honor, I don't object to the outbreak exam or to defense counsel's request. However, I believe counsel is new on the case. He's not aware of something that comprised the public defender of. Earlier this week, this defendant made threats to witness at preliminary examination.
Yes.
A new charge,
Sir, you need to face me.
a new charge has been authorized against this defendant as a result of these charges.
Okay, on Tuesday, I had a hearing for a situation that I was accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times, 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed else. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail. The very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, and I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Lorraine Washington is the eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Lorraine Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Stop. There was a video requested. Does the video show anything?
Your Honor, I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. I and she informed our advocate, and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Yeah,
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Yana, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for
First of all, I was not there, Mr. Michael Gaddy was. I'm not sure if this is being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things. They're look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My daughter's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm going to handle it at this juncture. All right.
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor that you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there. But I'll pass the matter. Sir, you need to just quiet down, please. Court does call the case of the people versus Lawrence Buckner.
Joseph McDonald, people, Your Honor.
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or 25.
After she testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, under people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at Exam. The condition of the bond in that case, case number 5-121. I'm sorry, I may have misread that case number. Was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case that he have no contact with the victim in Hudson, have a no-go to order as her residential place of employment. And frankly, Your Honor, is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is gravely concerning to me, and to our mind points to a need to set a significant bond to secure the safety of the public and of the state.
So I respond. So it describes you as an angry outburst. Doesn't rise showing any intention to anyone to do anything except that angry outburst. They went ahead and tried to charge a witness intimidation. This is something based on what they saw in context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. Making a line with a separate case, and that's exactly what's going on. You can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that context.
What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate. Should it be that type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once